A victory for people who wear dreadlocks and other black hairstyles in Jamaica. The Jamaican Court of Appeal has just handed down a major ruling dealing with dreadlocks and constitutional rights, and I'm here to break it all down for you. I'm calling this one the case of the dreadlocked daughter. Thank you so much for joining me courtside. Stay tuned. I don't know if you were aware of or if you remember that in 2018, a family, the Virgos, Dale and Shireen Virgo, enrolled their child in Kensington Primary School in St. Catherine in Jamaica. Now, Kensington Primary is a government school. It's a publicly funded institution. But when Shireen Virgo went to take the child to the first day of summer school, she was told that the school had a policy: no braids, no beads, no locking of hair. No braids, no beads, no locking of hair. What do those three things have in common? I'll wait. All right, I can't wait. But tell me what you come up with, comment down below. Now, what was the reason the school gave for this particular policy? This is what they said. They said parents do not wash their dreadlocked children's hair in a timely manner, and the hair gets ginger, and this had created serious lice infection issues in the past. For my non-Jamaican viewers and Jamaicans who maybe haven't heard that word for a while or who don't know it, ginger is a Jamaican term meaning fungal infection. So the school was saying here they didn't allow dreadlocks in children because of fungal infections and lice. And still when I hear it, lice and ginger, when I think about it, it still bothers me, because this is, as I said, a publicly funded school telling black Jamaican parents that their child can't have dreadlocks at school because of lice and ginger. So the Virgos sued. They said that their child's constitutional rights had been violated. And I just need to say, just for a moment, that I think it's outrageous that the Virgos had to go to court to get a court declaration on this issue. They had to go to court. They went to the Supreme Court where they lost, and they went to the Court of Appeal, and it took 6 years for this judgment to be handed down. And the government defended this lawsuit. They defended Kensington Primary at the Supreme Court and were asserting that the child's constitutional rights had not been breached, and they did so again in the Court of Appeal. This did not, I think, have to go this way. There could have been attempts to reach a settlement, a decision in terms of let's look at next steps. Let's agree on a series of actions to be taken to ensure that not just your child, but no Jamaican child will have to go through this and will have to be told what we were told. But that didn't happen, so they went to court. So it's important to say that when the matter became public, and people started to cuss and people are outraged, that the school did back down and say, hold on, the child can come here. No, she doesn't have to cut her hair. And when the Supreme Court judgment came out in 2020 that ruled against the Virgos, that said the child's rights had not been violated, again, the school said it's okay, it doesn't change anything, she can stay. So the child actually went to Kensington for 2 years, I'm told, before her parents moved her to another school. And, one of the things that we need to say as well is that there are a lot of people who, after they got their child into the school, would have dropped the matter, And the Virgos, big up to the Virgos who chose to go all the way on this, who went to the Supreme Court, lost, went to the Court of Appeal and got this important ruling, because litigation is stressful, it's time consuming, and it's expensive. At one point, the Virgos actually launched a GoFundMe account to help to pay for the legal expenses. And apparently they took it down because I'm told there were all kinds of controversies and negative comments being made. But yeah, litigation is expensive. And big up to the legal team as well, who really argued this one and got this win for the Virgos, and I'm going to say for the country as well. Okay, so the Virgos had said that several of their child's constitutional rights had been breached: right to freedom of expression, freedom of religion, right to privacy and family life, right to education, as well as right to equitable and humane treatment by public authority. And the court ruled for them on 2 points and against them on the other. So let's break it down, because I have to say I disagree with the Court of Appeal on some aspects of this ruling. Let's start with the big one. The court ruled that Kensington Primary had in fact violated the child's right to freedom of expression. Now, what does freedom of expression have to do with hair? What the court said was that several cases have said that how a person attires himself or herself may constitute a form of expression. In other words, what you wear is also a way of expressing yourself. Expression is more than just talking. And the court quoted a case called McEwen that came out of Ghana, in which the president of the Caribbean Court of Justice, Justice Saunders, he said this: how individuals choose to dress and present themselves is integral to their right of freedom of expression. And the Court of Appeal said there were also other cases that support the principle that the way a person wears their hair is a mode of expression. So, is everything expression? Court of Appeal said no. There are 2 things you have to look at. One, you need a physical manifestation, and then the physical manifestation has to have content that conveys a meaning. What does all that mean? Well, in this case, the locks, the child's dreadlocks, were the physical manifestation. Now, do you think that the dreadlocks conveyed any kind of meaning? What do you think? This is what the Court of Appeal said. They said the evidence in this case goes beyond the mere physical appearance. It speaks to ZV's identity. ZV is what the child is called in the court rulings, so to protect her privacy. And the Court of Appeal went on to say this. They said the full court, that's a 3-judge panel of the Supreme Court that heard this case, they said the full court was wrong to find that the policy did not infringe ZV's right to freedom of expression. The dreadlocks were the physical manifestation of the expression of a Nazarene lifestyle, which was the content. The court said there is sufficient evidence from ZV's parents that ZV wore the dreadlocks to express her existence and identity. ZV's right to freedom of expression was therefore engaged. So ticky there, violation of the right to freedom of expression. So that's a big victory. So let's talk about what the court said in relation to freedom of religion, because the court did not agree that the child's freedom of religion, right to freedom of religion, had been violated. And I know people would be saying, how come? Because we all know Rastafarianism is a religion. But the court said a couple of things. They said, one, the father, Dale Virgo, in his affidavit had said that the families were not Rastafarians. Now the mother, Shireen, in her affidavit had said the family was Nazarite, meaning that one feature of being a Nazarite is that you don't cut your hair. But the court also said that freedom of religion didn't come into play because the school was not told at the beginning that the reason the child's hair couldn't be cut was for religious reasons. And the school's principal gave an affidavit to the court in which she said once she became aware of the fact that it was a religious reason why the parents were saying the child's hair couldn't be cut, she was saying at that point the school's policy of no locking of hair would not have applied to the child. So the Court of Appeal said she couldn't claim her right to freedom of religion. She couldn't claim that that right had been breached because she had not notified the school of her religious beliefs, nor had she asserted a right to freedom of religion. The court said once notified, the school promptly conceded that the policy did not apply to her. Honestly, I'm still thinking through my position on this one. I really haven't come to a settled position on this one, so I'm just going to leave it there. I'm neutral on this one, not saying if I think the Court of Appeal was wrong or right here. I do think the Court of Appeal was wrong on the issue of education. So this is what the Constitution says. In the Charter of Rights, there is a right to publicly funded tuition in a public educational institution at the pre-primary and primary levels. And what the Court of Appeal said is that this right was breached. How come? There are regulations under the Education Act that govern the situations in which you can bar a child from school. So if a child wants to enroll in a school, you can bar the child if there's no space, or you can refuse to admit the child for some other reason that the minister approves. When it comes to health, you can bar a child from school if the child has a communicable disease or some other kind of infestation, but the child would only be shut out of school for the period of that disease or infestation. So I'll come back to that in a moment. Now, what the Court of Appeal said in this case is that the right to education as contemplated in the Charter is not an absolute right, and there are limitations. The school sought to exclude ZV. ZV, as I may have mentioned, is what the child is called in the court rulings to protect her privacy. So the school, the court said, sought to exclude ZV, but it must be recognized that there is no right to attend any school of one's choice. The right only embodies access to education. ZV had already gained access to the school, but was later excluded. Excluding ZV was unlawful, but did not amount to a denial of her right to education, since she was free to seek education at another institution. So I have a huge problem with this part of the ruling, because what the Court of Appeal is saying here is that, okay, the child and her family can go to another school and try to get her enrolled there, because they're saying there wasn't a system-wide policy of no braids, no beads, no locking of hair. But at what point is the right then engaged? How many schools does ZV have to go to with her family and be barred before her right to access education is engaged? And as well, why is it that the onus is being put on the child and her family to find a school that will accept them, rather than the onus being on the school not to bar the child? I think the Court of Appeal has looked at this issue backways. I don't think the issue at all is of whether you have a right to attend a particular school, because what the court is saying, you don't have a right to attend Kensington Primary or ABC School, you have a right to attend a school. I don't think that's the issue here at all. The issue is that no school, no publicly funded institution should be allowed to bar a child for reasons that are unlawful, unconstitutional, and unjustifiable. And if a school does that, as was done here, then yes, they should be held to have violated the child's right to education. So Court of Appeal, I part company with you on this. I think you went wrong here. Another right that the Virgos were saying had been violated was a child's right to equitable and humane treatment by any public authority. So what the Court of Appeal said is that when it comes to the inhumane part of it, they said there was no evidence that there was inhumane treatment. They said the ban on the wearing of a particular hairstyle to school cannot by itself be considered inhumane treatment of the wearer of that hairstyle. The court did say, though, that she had been treated inequitably, and the court said the policy discriminates against people who wear dreadlocks, and that treatment being both negative and different from the treatment meted out to other students at the school amounts to inequitable treatment. There was also the issue of her right to privacy and family life. And again, the Court of Appeal said this had not been violated. The court said there had been no invasion of or intrusion into the Virgo's private sphere or family life. Again, parting company with the Court of Appeal. I think they're wrong on this. Being a part of the Virgo family meant having locks, meant not cutting your hair, meant being a Nazarite. What the school did in saying that the child's hair would have to be cut, they were then striking at one of the essential features of being a member of this family. So yeah, I think her right to family life was infringed here by the school. So again, as I said, I think the Court of Appeal was wrong on this one. So to summarize now, the Court of Appeal held that two of the child's constitutional rights had been breached: her right to freedom of expression and her right to equitable treatment by a public authority. So having found that the rights had been breached, the court now moves on to figure out whether or not the breaches were justifiable, because the Constitution does provide for this. Rights are not absolute. And the way the Charter puts it, the Charter of Rights in the Jamaican Constitution, are the restrictions on the rights demonstrably justifiable in a free and democratic society? So what do you think? Could Kensington justify their policy of no braids, no beads, no locking of hair? Here's what Kensington had to say. Here's their justification. Some of these hygiene issues related to the poor grooming of the hair of female students. There were instances where female students would have braided hairstyles for prolonged periods, such as a school term, without sufficient care being given to the hair, resulting in the hair having an unpleasant smell. These hygiene issues gave rise to conflicts between students, resulting in incidents that disrupted classroom activities and which ultimately led to a reduction in the teaching and learning contact hours. One such incident occurred during class when a student who had a locked hairstyle was pushed off the bench by another student who was offended by the smell of the student's hair. So the court summarized this by saying the purpose of the policy was to ensure personal hygiene within the school, to prevent conflict between students which interrupted classroom activities, and prevent the outbreak of lice and fungal infestation. So, was this justifiable? Court of Appeal said no. So yeah, good job on that one. The court said banning the impugned hairstyle, in other words the dreadlocks, would not necessarily prevent the outbreak of lice or fungal infection because there's no evidence that other hairstyles would not cause the same undesirable results. Now, in addition, if you're going to be restricting a right, the actions you take have to restrict the right as little as possible. In other words, don't bring a sledgehammer to kill a mosquito. And the court said Kensington's policy went too far. Now, remember I was telling you about the regulations that are in place, so you can send a child home in certain circumstances or bar a child from school. So if it is that one child has a particular problem, you can send that child home until that issue, say a hygiene issue, an infection issue, until that issue has been dealt with. What you're not supposed to do now is implement this blanket policy that goes way further than this one child. And the Court of Appeal said that the policy does not limit ZV's rights as little as is reasonably possible, that it's not the minimal method needed to address the mischief, and the policy therefore should be ruled unconstitutional. So, summarizing, 2 constitutional rights breached: the right to freedom of expression, the right to equitable treatment by a public authority, and there was no justification for the breach of those rights that stood up to the scrutiny of the court. Now, before I leave you, let me just say a word to my Rules Are Rules friends. So if it is that you're hearing all this, you've been seeing the reporting and you're saying, oh my gosh, schools can't make rules anymore, there's going to be no law and order, we're going to descend into chaos, the society is lost. Look, not a soul is saying that schools should not be able to make rules. Not a soul is saying that schools should not try to uphold law and order, to maintain discipline, to maintain standards of hygiene. What is being said are a couple of things. One, rules need to be reasonable and rational, and they can't be too broad. You can't say that one student from community X came in with a problem and therefore we are going to bar all students from community X, and that's the equivalent of what happened here. Number 2, you can't make rules that breach students' constitutional rights. That's it, without justification. And number 3, let us stop upholding and pointing to rules that were either imposed on us or that we have adopted from our former colonizers who hated black hair. At some point, we need to accept that we've been brainwashed into thinking that black hair is bad, that it's unkempt, I know you all have heard that word, that it's untidy, that it's somehow associated with criminality, with indiscipline, with lawlessness. And we have to acknowledge and start to talk about the fact that a lot of these rules around black hair that are in place in society, in our workplaces and in our schools are based on discrimination. We can talk another time though. That's where I have to leave it. Thank you so much for being with me courtside. I'm Dion. I'll see you next time.